If you've been told that the goal of estate planning is to put everything you own into your living trust, I need you to pause for a moment, because that advice, followed blindly, could actually hurt your family instead of helping them. Picture this. A husband and wife spend an entire weekend retitling everything they own into their new living trust. Their house, their bank accounts, and yes, even the family car sitting in the driveway. They feel proud. They feel responsible. They think they've done everything right. Then, 3 years later, their adult son borrows that car, and through no fault of his own, he's involved in a serious accident. When the lawsuit papers arrive, they're not just addressed to their son, they're addressed to the trust itself, the same trust holding the family home, the savings, and the inheritance meant for their grandchildren. One overlooked detail in their planning just put their entire life's work at risk. This is not rare, and it's not dramatic for effect. It happens because most people assume that more is better when it comes to funding a trust, when the truth is that certain assets should almost never be placed inside one. Today, we're going to walk through exactly which assets those are, and just as importantly, why moving them into your trust can backfire. Before we go any further, let's be clear about what this video is and isn't. This channel exists to help you understand estate planning concepts in plain English, so you can have informed, confident conversations with the professionals who help you build your plan. I am not an attorney, and nothing in this video should be taken as legal or financial advice for your specific situation. Estate laws, probate procedures, and tax rules vary significantly from state to state, and sometimes even county to county. So as we go through this together, think of it as a foundation of understanding, not a substitute for sitting down with a licensed estate planning attorney in your state, who can look at your actual documents, your actual assets, and your actual family situation. With that said, this information matters more than you might think, because the mistakes we're about to cover are some of the most common ones estate planning attorneys see, and they often go undiscovered until it's too late, until a family is already in crisis, already grieving, and already dealing with a legal mess that could have been avoided entirely. By the end of this video, you're going to understand exactly which categories of assets generally do not belong inside a revocable living trust, the real reasons why, including tax traps, liability exposure, and administrative headaches, and what you should be doing with those assets instead, so your estate plan actually works the way you intended. This is the kind of information that, once you understand it, you'll wonder why nobody explained it to you sooner. So if topics like this, the kind that protect your family's future, matter to you, take a second to subscribe, because we publish new videos every week breaking down exactly this kind of practical, plain English estate planning education. Now, let's get into the first asset on our list, and it might surprise you because it's something almost every family owns. Let's start with vehicles, because this is the mistake we opened the video with, and it's astonishingly common. When people set up a living trust, they often get an instruction sheet or a checklist that says, retitle your assets into the trust. And vehicles, being one of the most visible things people own, often get swept up into that process without a second thought. Here's the problem. Vehicles already have a built-in, simple way to transfer ownership after someone passes away, completely separate from your trust. In most states, your loved ones can transfer a car, a boat, or other titled vehicle to a beneficiary using nothing more than a copy of the death certificate and some simple paperwork through the Department of Motor Vehicles. There are even specific beneficiary designation forms in many states designed just for this purpose, allowing a vehicle to pass directly to a named person without going through probate at all. So if a vehicle already avoids probate on its own, why complicate things by retitling it into a trust? You're adding a step that creates risk without adding any real benefit. And here's where the risk comes in. The moment you retitle a vehicle into the name of your trust, you have essentially put a sign on that asset announcing, this vehicle is owned by a trust. Why does that matter? Because if that vehicle is ever involved in an accident, and someone decides to pursue a lawsuit, their attorney is going to look at who legally owns that vehicle. If the owner is your trust can be named directly as a defendant. That means the very vehicle of an unrelated accident, maybe your teenage grandson borrowing the car, maybe a fender bender that turns into a larger injury claim, suddenly has the potential to expose every single asset inside that trust to legal liability. Your home, your retirement savings, if you've placed them inside, your life's work, all potentially exposed because of a decision that had nothing to do with estate planning and everything to do with convenience. On top of the liability concern, there's a practical headache that catches people off guard, and that's insurance. Auto insurance companies are built around insuring individuals, not legal entities like trusts. When you tell your insurance company that your vehicle is titled to a trust, you'll often run into confusion, additional paperwork, sometimes higher premiums, and in some cases, insurers who simply don't know how to properly underwrite the policy. This isn't a universal rule. There are some situations, particularly involving privacy concerns or unique ownership structures, where titling a vehicle differently might make sense, and that's exactly the kind of nuanced decision a licensed attorney in your state should weigh in on. But for the overwhelming majority of families, the simplest and safest approach is this. Keep vehicles titled in your own name. Use any state-specific transfer on-death vehicle designation if your state offers one, and clearly state in your trust's letter of instruction who you'd like to receive the vehicle. Your successor trustee can then handle the simple transfer using the death certificate without ever exposing your trust to liability. Let me give you a sense of how this plays out in real life. Imagine a retired couple who built a comfortable but modest estate, a paid-off home, some savings, and 2 vehicles, including a truck the husband loved and used for weekend projects. Following generic advice they found online, they retitled both vehicles into their trust, right alongside their home and their bank accounts. Years later, their adult grandson, who lived with them while attending community college, borrowed the truck to help a friend move. On the highway, a tire blew, the truck swerved, and another driver was seriously injured. The injured driver's attorney did exactly what attorneys are trained to do. They investigated who owned the vehicle. When they discovered it was titled to a family trust holding a paid-off home and a 6-figure retirement account, the lawsuit named the trust directly. What started as a vehicle accident involving their grandson became a multi-year legal battle threatening the couple's entire estate, the same estate they had worked their whole lives to protect for their children and grandchildren. This is not a story meant to scare you for the sake of it. It's a story meant to illustrate exactly why the placement of even one seemingly unimportant asset can have consequences far beyond what most people expect. Now let's move to our second major category, and this one trips up even people who consider themselves financially savvy: retirement accounts. This includes your 401k, your traditional or Roth IRA, and similar qualified retirement plans. Here's something a lot of people don't realize. These accounts are not simply bank accounts that hold your money. They are legal arrangements in their own right, governed by federal tax law and by the specific custodial agreement of the financial institution holding them. When you open a 401k or an IRA, you're not just opening an account, you're entering into a trust-like agreement that already has its own rules about who owns it and how it passes to others. So when someone suggests retitling your IRA into the name of your living trust, what they're often unknowingly suggesting is a complete liquidation of that account. Why? Because the moment ownership of a retirement account changes from you personally to a trust, the IRS often treats that as a distribution. That means the entire balance can become immediately taxable in that year, potentially pushing you into a dramatically higher tax bracket and erasing decades of tax-deferred growth in a single painful moment. This is one of the most expensive mistakes someone can make in estate planning, and it's almost always made with good intentions and zero awareness of the consequence. So what do you do instead? With retirement accounts, the strategy is not about ownership, it's about beneficiary designation. You leave the account in your own name, but you carefully designate who receives it when you pass away. For married couples, this often starts with naming your spouse as the primary beneficiary, which allows for favorable tax treatment and rollover options. But here's where many people stop thinking it through, and where real problems begin. For the contingent beneficiary, the person or entity who receives the account if your spouse has already passed, many people simply write in their children's names directly. That might sound reasonable, but consider what it actually means. If both spouses pass away, say in an accident, and the children are still young, in their 20s for example, those retirement accounts will be paid directly to those children, outright, with no protections, no structure, and no oversight, regardless of what your trust says about distributing assets gradually or protecting them until a certain age. All of that careful planning you built into your trust becomes meaningless for these particular accounts because the beneficiary form, not the trust document, is what actually controls where the money goes. The solution that many estate planning attorneys recommend is naming your trust as the contingent, or sometimes even primary, beneficiary of these accounts, but only when that trust has been specifically drafted with provisions to receive retirement assets. This matters enormously because retirement accounts come with specific tax rules about how quickly they must be withdrawn after the original owner's death. And a trust that isn't properly structured to handle this can actually accelerate taxes or create exactly the kind of distribution chaos you were trying to avoid in the first place. This is a highly technical area, and it's one of the clearest examples of why this entire topic needs to be discussed with a licensed attorney who understands both your state's trust laws and current federal retirement account rules, because mistakes here are not easily undone. Our third category, and one that often surprises people, is life insurance. Like retirement accounts, life insurance policies already come with a built-in mechanism to bypass probate entirely, the beneficiary designation. When you pass away, the insurance company pays your named beneficiary directly, generally within weeks, without any court involvement at all. So there is typically no need to place a life insurance policy itself into your living trust. The more common and more effective approach is to name your spouse as primary beneficiary and your trust as the contingent beneficiary, so that if your spouse is no longer living, the proceeds flow into the trust and get distributed according to the careful instructions you've already laid out, rather than landing in the hands of a beneficiary who may not be prepared to manage a large sum responsibly. There is, however, a more advanced consideration for families with significant life insurance coverage, particularly those who may be approaching their state's estate tax threshold. In certain situations, a specialized tool called an irrevocable life insurance trust may be used to hold a policy outside of both your living trust and your taxable estate entirely. This is a sophisticated strategy, generally relevant for larger estates, and it absolutely requires personalized guidance from an attorney familiar with your state's estate tax rules, since thresholds and exemptions vary considerably across the country and can change with new legislation. Now let's talk about a fourth category that doesn't get nearly enough attention: health savings accounts and similar tax-advantaged medical accounts. Much like retirement accounts, these are governed by their own federal rules and custodial agreements. They are not designed to be retitled into a trust, and doing so can again trigger unintended tax consequences and disqualify the special tax treatment that made the account valuable in the first place. The correct approach, once again, is a proper beneficiary designation, reviewed periodically, especially after major life events like a marriage, divorce, or the passing of a previously named beneficiary. And our fifth category, often overlooked entirely, is certain types of business interests, particularly when you're an active owner or partner with specific operating agreements in place. While some business interests absolutely can and should be transferred into a trust, doing so without carefully reviewing your operating agreement, partnership agreement, or corporate bylaws can sometimes violate existing contractual terms with co-owners or trigger buyout clauses you never intended to activate. Some agreements explicitly restrict ownership to natural persons rather than trusts, while others require partner approval before any ownership change. This is an area with enormous variation depending on your specific business structure and your state's business laws, which makes it absolutely essential to involve both your estate planning attorney and, ideally, a business attorney familiar with your existing agreements before making any changes. So let's talk about the myths and mistakes that tend to surround this entire topic, because misunderstanding these points is what creates real problems for real families. The first myth is the belief that a living trust automatically protects every asset from lawsuits the moment it's funded. That's simply not accurate. A revocable living trust, the kind most people set up for probate avoidance and incapacity planning, generally does not shield assets from your own personal liability while you're alive, and titling a high-risk asset like a vehicle into that trust can actually expand liability exposure rather than reduce it. The second myth is thinking that beneficiary designations are a minor afterthought compared to the trust document itself. In reality, for assets like retirement accounts and life insurance, the beneficiary form often overrides everything written in your trust. If those forms haven't been updated or properly coordinated with your trust, your entire estate plan can fail silently, without anyone realizing it until after you're gone. The third myth is assuming that funding a trust is a one-time event you complete and forget about. Your assets change. You open new accounts, sell vehicles, refinance homes, and update retirement contributions. An unfunded or partially funded trust is one of the leading reasons families end up in probate court anyway, defeating the entire purpose of having set up the trust in the first place. And the fourth myth, perhaps the most dangerous one, is believing that because a strategy worked for a friend, a neighbor, or someone in a video online, it will automatically work the same way for you. Your state's laws, your family structure, your asset types, and your specific goals all matter. And generic advice followed without professional review is exactly how families end up in the situations we've described today. So what should you actually do with this information? Start by making a simple list of everything you own, every account, every vehicle, every policy, every property. Next to each item, note how that asset is currently titled and who, if anyone, is listed as a beneficiary. Then identify which of these fall into the categories we discussed today: vehicles, retirement accounts, life insurance, health savings accounts, and active business interests, and set those aside from your general trust funding checklist. For vehicles, check whether your state offers a transfer on death title designation, and make sure your wishes are clearly written into your trust's letter of instruction. For retirement accounts and life insurance, review your beneficiary designations today, not someday, and consider whether your trust should be named as a contingent beneficiary, especially if you have minor children, blended family considerations, or beneficiaries who may not be ready to manage a large inheritance responsibly. For business interests, pull out your operating agreement or partnership agreement and read the section on ownership transfer before assuming your business simply slides into your trust like everything else. And finally, take this entire list, the one you just created, to a licensed estate planning attorney in your state. Walking into that meeting with organized information, rather than a vague sense that you should probably set something up, will save you time, save you money, and most importantly, help ensure nothing falls through the cracks. At the end of the day, a living trust is one of the most powerful tools available for protecting your family, avoiding probate, and making sure your wishes are honored exactly as you intended. But like any powerful tool, it has to be used correctly. The goal was never to blindly fill it with everything you own. The goal is to thoughtfully place the right assets inside, while keeping certain other assets outside, using the proper beneficiary designations and titling strategies that already exist specifically for them. When you understand the difference, you're not just protecting paperwork, you're protecting your spouse from financial stress during an already painful time, you're protecting your children from unnecessary court battles, and you're protecting the legacy you've worked your entire life to build. That, more than any document or any account, is really what this is all about. Before you go, let's bring it all together. Everything in this video is intended for general education purposes only, and it is not legal, tax, or financial advice for your individual situation. Estate planning laws, probate procedures, and tax thresholds vary significantly from state to state, and they can change over time. Before making any decisions about your trust, your beneficiary designations, or your overall estate plan, please talk to a licensed estate planning attorney in your state who can review your specific assets, your family situation, and your goals. If this video helped clarify something you'd been wondering about, do us a favor and hit that subscribe button, because we're publishing new videos every single week designed to help you and your family navigate estate planning with clarity and confidence instead of confusion and fear. Thank you so much for spending this time with us today, and we'll see you in the next one.